further hearing on the appeal of army application AM Belarus against the single state of the Home Department.
Mr. Drabble.
Lord Milady, can I go back to the submissions I started to make yesterday about the approach this court should take to RA Iraq? And the submission I made yesterday, formulated in fact before the argument started, was that the court should endorse the guidelines given in RA Iraq. Thinking about that, that may have set an unnecessarily high target for myself, because it's not necessary to today's case. It will be sufficient for my purposes that this court recognises that the matters referred to in each of the four stages are relevant to the exercise in a limbo case. That in fact the approach taken in RA Iraq will produce a lawful answer, whether or not the four stages are strictly necessary. And finally, that as applied by the upper tribunal in the present case, the application of RA Iraq did produce a lawful answer. And the last bit is the important bit, is the detail of the reasoning of the upper tribunal decision, which at the end of the day, this court has to consider. So can I then look at each of the four stages? RA Iraq starts at page 727, tab 11 of the authorities bundle. And if we go to paragraph 61, yes, paragraph 61,
Page.
Yes, sorry, no, I'm getting confused because I'm reading paragraph numbers in some of the citations rather than the paragraph numbers in RA.
739.
So it's page 739, stage 1. Heading is distinguish between prospective limbo and actual limbo. Now, whether or not it's necessary to do that, it plainly is necessary to bear in mind that there may be cases in which the immigrant is already in actual limbo, and all cases in which there is a prospective limbo. So you need to look at the present situation, you need to look forward. There's no magic about that. And that is the present case. And so whether or not you need to have a stage 1 that requires a formal finding about actual limbo or prospective limbo, they're both all matters that need to be thought about, and the RA Iraq itself recognised in the last sentence of paragraph 64 that each case will depend on its own facts and the periods involved. So it's calling, even at that stage, for a detailed analysis, which is exactly what it received in the upper tribunal case. So we say there's nothing vitiating about stage 1. It doesn't vitiate the approach of RA Iraq, whether it's necessary in the formal way that the Court of Appeal envisaged is another matter. Stage 2 is remoteness. Now, plainly, in all the case law that my learned friend relied on does have this effect, that it demonstrates the need to think about whether what the prospects are of the obstacle to returning to the country of origin or wherever it is being removed. It's necessary to think about that. And paragraph 66 of RA Iraq correctly, as I would accept, recognises that if the prospects of removal are not remote, there will be a real difficulty about whether the public interest in deportation could be overcome by considerations of private or other convention rights, such as to create a formidable or potentially insuperable obstacles. That's not put in absolute terms. It's correctly not put in absolute terms. I completely accept the thought that lies behind it. But it can't be translated into, none of this can be translated into absolute principles.
But is there a danger if you have a checklist of this kind in a situation where stage 1 and stage 2 really are entirely factual questions, and the facts that may arise in any case are infinitely variable? Is there a danger that the tribunal closes off its mind? And I just wonder why you need these elaborate questions and elaborate sub-questions.
I think the position that I've now got to is that you may well not need 4 stages. You do need to think about the subject matter.
Well, you need to ask, is he in a limbo state?
Yes.
And what are the prospects of
removal? And then you need to ensure that your factual analysis that will lead to the balancing exercises is complete in order to make sure you're capturing every factor that might come into play, as the present case demonstrates. There's the need to make sure that you're picking up a non-paradigm case, so you do need a complete analysis. Now, whether you need to use the language of stage 3, I am now agnostic about it, but you do need a complete and systematic analysis of the facts. And stage 4, similarly, requires an analysis of where the public interest lies and how it is to be balanced in the individual case.
But it's not a freestanding Article 8 balancing exercise. It's one to be conducted in accordance with the statutory scheme.
Yes. Well, yes, can I just say a word about that?
Yes.
When we come to well, I have jumped over and meant not to paragraphs 61 and 62 of the upper tribunal of our Iraq. And it's just to make the obvious point that what the Court of Appeal is doing in our Iraq is approaching what it sees as a particular issue of limbo. One can, I assume, that the Court of Appeal took it for granted that when you come to the balancing exercise, you do so in accordance with the normative guidance that has been given in the statute. You carry out the balancing exercise as you would carry it out in each and every deportation case that raises the issues arising under the statutory scheme. And when we come to whether all of this matters, when we come to what the tribunal did, the upper tribunal in mind, that is very precisely what they did. They went on straight into the statutory scheme. So, I mean, I will completely accept the proposition that if this court were to be drawing up guidelines, it would have to recognise the existence of the statutory scheme. But that doesn't have the consequence that the upper tribunal fell into ever. So if we now go from those short points about RA Iraq and on to what the upper tribunal actually did,
did you want to say anything about the interaction between paragraph 71 and 72 in RA Iraq?
Well, it's a general theme of my submissions, as I think I did say yesterday, that none of the case law lays down a rule that shows that the upper tribunal exercise, which I'm just coming to, created any error of law. And the observation in 71 that the public interest may be so weakened that Article 8 rights may tip the balance will normally only arise in cases where it's clear the public interest in immigration is extinguished, because in practical terms there's no realistic prospect of effective deportation. It, as a general observation, is correct, as my lady's observations in Hamza make good, but they don't, neither those observations, which I was going to come to later, but I will do it very shortly, or the similar observations in Abdullah, lay down an absolute rule that the public interest can never be outweighed where there's an element of self-inducement. And that's the way in which the upper tribunal approached it.
Yes, thank you.
Yeah. So going then, if I can put RA Iraq away for the moment and pick up the upper tribunal, just run through the structure of the case, the structure of the upper tribunal decision in a way which is the court will already be familiar with. The upper tribunal is at page 124. I have it at page 124. Well, the passage I was going to go straight to. My learned friend didn't take your lordships, my lady, in detail to the approach of the upper tribunal to the facts, and at 124 to 125, the court will see the upper tribunal setting those out.
So which paragraph number, sorry?
It's actually paragraph 44 at page 125, 44 through to 47.
Different page numbers.
So, yeah, I'll be working off page numbers which are in the key documents bundle. Paragraphs are 44 through to 47. If we've all located the upper tribunal decision, which is obviously also in the main court bundle, then I can work just off the paragraphs, and I hope that will work.
Yes. So paragraph 44 and following.
44 through to 48, actually. These are picked up later. But if we just
You're referring to these facts in order to establish what proposition?
in order to establish that there was a strong case described, as we shall see in a moment, by the upper tribunal as very compelling circumstances arising from the impact of the restrictions on my client's private life because of the situation in which he found himself without it being regularized. So I mean, go straight to one point. My learned friend says the upper tribunal described his private life as small. That's true, but the upper tribunal plainly considered there was a considerable impact on his well-being because of the restrictions on his private life. And if your lordship will see that from the first sentence of paragraph 46. And your lordship, my lady, will have seen the citation from Mr. Carnick's skeleton in paragraph 48. Now, it's that factual background that led the upper tribunal, if we jump ahead in the decision just for a moment to paragraph 148, to describe his Article 8 case as very compelling. The whole sentence of 148, of the first sentence of 148, the continuation of the remoteness of removal, the fact that taking the applicant out of limbo in 2021 would not materially damage the principle of deterrence inherent in the statutory scheme, and having regard to the overall rationale of paragraph 276 ADE, lead us to conclude that while not extinguished, the public interest in effective immigration control is weakened to the point when it is capable of being outweighed by the very compelling circumstances of the appellant's Article 8 case. So we have there a recognition that the matters they have described earlier in the decision, in particular in paragraphs 44 to 48, do give rise to very compelling circumstances when one is considering the Article 8 case. And that is obviously a direct reference to the statutory scheme. So going back to the overall structure of the upper tribunal decision and trying to deal with Milena.
Do they ever describe what the compelling circumstances are? I mean, you say it's a reference back, but it's not what they actually say.
The short answer is no. I mean, in the sense, can I find a piece of language that shows that what they're discussing in the paragraph I've just read, 148,
They seem to talk about his medical condition in terms of an assessment of capacity for self-improvement as an aspect of the public interest.
Yes, but not exclusively that. I mean, you ought to go back to 44 through to...
I was thinking of paragraphs 144.
Yes, I'll come to that in a moment, because I want. But we go back to the description of his medical condition the first time round, as it were, in 44 through to 48.
But I thought 44 was the submission being made.
Yes,
46. The first sentence you draw our attention to, I mean, that's recording a submission made.
Yes. Yes, but it's completely clear from where we're now going that the tribunal accept that approach.
Well, the detailed factual analysis, according to RA, is carried out at stage 3. That's where you get the factual findings that are then fed into the stage 4 balancing exercise if you're applying an RA approach, isn't it?
Yes.
And those are at 123 to 129. So that's where we should find the findings that they're then going to rely on.
Yes.
Yeah.
And that is referring to the same evidence about medical conditions that Mr. Carnick has referred to in paragraphs 44 through to 48.
Where do we have, if those are the factual findings at stage 3, upon which you base the balancing exercise at stage 4, where is, just remind me where the factual finding is that he had a method of actually getting himself out of limbo by telling the truth.
We don't find it in paragraphs 123 to 129. We do find it in the discussion of remoteness in 121 and 122. So immediately before going into the factual analysis of stage 3, the tribunal have made the observations in 122 and indeed they expressly say in the second sentence of 122, the fact that this is because the applicant has maintained an entrenched position will be relevant when we come to stages 3 and 4 of the analysis. So they're approaching 3 and 4 against the background in which their starting place is that there's an entrenched position which could be changed. It's the whole basis of the remoteness analysis in 122.
So where does it reappear in their assessment of stages 3 and 4? They say it's going to be relevant to that.
It's absolutely implicit and fundamental to the analysis of the concept of deterrence in the passage in which my learned friend criticises, and which I want to spend just a little bit of time on, of 134 through to 150. It's crucial to read all those together. Now,
Do you agree that that the actual balancing exercise is conducted at 147 and 147 to 149?
No. The balancing exercise is conducted in the whole of the run of paragraphs from 130 through to 150, principally to 148. But it is a mistake which my learned friend submissions make to analyse each paragraph separately without the understanding that they all relate to each other. I'm going to make this submission when we come to the concept of deterrence. My learned friend concentrates, for example, on paragraph 136, which talks about what the impact will be on public confidence of a grant of leave to my client, and says, well, that's not talking about the deterrent effect of other immigrants, but that is to read 148 in isolation and not as part of this run of paragraphs which include, for example, 148. So if you take a fair reading of this decision, it is maybe a reason why RA Iraq is a bad idea, but you start with why it is that the tribunal think my client has a limbo argument. That is 122. It's inherent in that he's maintaining an entrenched position. It's precisely what they say. I wish they hadn't said it, because otherwise I would have a different factual argument. But that is the basis on which they approached it.
That's to treat his entrenched position as, in effect, something in his favour in this analysis. That's what gets him into a situation where he can complain that he's in a limbo case, which Article 8 ought to offer him the exit route.
I mean, I don't accept that it's possible to describe it as in his favour or not in his favour. It just is. He has an entrenched position. The tribunal know, because they say so in terms that they are not dealing with a situation. Well, they consider that they're not dealing with a situation where it's medically impossible for my client to make the application or deal with Belarus. And the whole of their analysis about deterrence proceeds on the basis that that is the position. Now, if they adopted a different factual approach in 122, they might well have reached the conclusion that removal was impossible, not just remote. It's a simplification to say that it's treating it in my client's favour. It just is what it is. They are saying it's remote. That means they're fully aware that the position could change, but saying that because it's gone on for so long and so on, the public interest is not extinguished, because the recognition that it's not extinguished is in the terms of this decision a recognition that it's not an absolute position. Not extinguished, but reduced to a point where it is outweighed by the other aspects of the impact on my client's private life. I mean, it may well be that this exercise is demonstrating the danger of stage 2, stage 3, and stage 4. I mean, maybe making the point against my own formulation of yesterday myself, but you must read this whole run of paragraphs together.
So where do they bring the factual findings of paragraph 114 and 115 into consideration in the balancing exercise?
Well, it's the core of their deterrence argument. They are saying, we know effectively when we look at the detail of what is being said in 134 to 138, they are starting from the proposition that this is where they're dealing with a case where the prospects of removal are remote, not impossible.
But I think you recognise that the ability of a person to change his status from being in limbo to being deported under his own control is a factor to be taken into account under the balancing exercise.
Absolutely.
My simple question is, why do they do it?
They do it because they're starting. No, they do it because I'm going to just repeat myself. They do it in the whole run of paragraphs from Well, the whole run of paragraphs that deal with, ask the question, is removal impossible? The answer is no, because he could change his mind, C110. Where does that leave us in terms of analysing the public interest? It's axiomatic we're dealing with a case where he could change his mind, because that's why we're dealing with a remoteness case, not an impossibility case.
Would it be an error of law if they didn't do it? If they hadn't done it?
If it wasn't implicit in their whole case, they recognise that he might change his mind, yes, it would be an error of law. I mean, I can only repeat that it's just not a realistic reading of this. The problem that they're grappling with is that this isn't an impossibility case because he might change his mind. Where does that leave us? And effectively they're saying that in the ordinary case, I mean, I'll come back in detail to the deterrence paragraphs because it's quite important to get that right. But effectively what they're saying is that in the ordinary case, if a position is someone who can change his mind, then he will fail. And that is precisely what R.A. Iraq said in the passage that we were looking at in paragraphs 73 to 72 of R.A. Iraq. But does that normal conclusion, so the reason of the upper tribunal go, carry over into this case? And the answer is no, because of their analysis of the position on deterrence. I mean, so can I now kind of go to the paragraphs on deterrence and see what's implicit in those paragraphs?
Just before we do,
yes, of course.
I just wanted to draw your attention to paragraphs 133 to 134, because it seemed to me that that was the point at which the tribunal addresses the effect of the non-cooperation on the part of the appellant. They say, despite what is said in paragraph 71 of RA Iraq, and notwithstanding we have given a positive answer at stage 2, so that's where they're referring back to stage 2, we do not consider that the public interest can be said to have been extinguished. But then in 134, they describe it as a residual public interest resulting from the applicant's problematic action. So doesn't that indicate that, in fact, they're treating it, in effect, in his favour, that he's able to non-cooperate?
No. The reason that they regard it as a residual public interest, I continue to stress this, is in the run of paragraphs that follow on from there. You need to read this in the light of what they do say about the public interest, which recognises that in the normal case, the public interest will weigh in favour of immigration control. The rhetorical question, is that so here? No, for the reasons given in 135 onwards.
But aren't they treating it as his entrenched position as a fait accompli that the public authorities just have to put up with? And that has resulted in them having only a residual public interest, not the usual full public interest.
No, the reason why they say the public interest is residual is because they look at what the impact will be on immigration control of granting my client some form of regular status, despite the fact he could change his mind. What is the impact of that? That's the whole question that they're dealing with. What will be the impact on the public interest in immigration control of granting my client permission to stay, despite the fact that he could change his mind? That's the question which lies entirely behind 135 through to 150.
But if he could change his mind, why is it a residual public interest? Why isn't it the full public interest in enforcing immigration controls?
Because it's a one-off case, and the issues of deterrence and so on apply in the way in which they've analysed. You don't end at 134. You go on to say, well, why is it they're saying that the public interest is weakened? And the answer to that is given in 135 onwards.
Well, I mean, speaking for myself, I rather read 133 to 134 as identifying a weakened form of public interest, and then the following paragraphs as indicating why that weakened form of public interest wasn't good enough to outweigh the private interest.
No. I mean, this is actually reviving my faith in looking at paper copies. Don't look at this in isolated paragraphs. 134 leads straight into 135.
But it supports my Lord's point, doesn't it? Because that is exactly the point my Lord is making. Because what is said at 134 is, normally the balance will tip in favour of the individual only when the public interest is extinguished. Here they're saying there's only a residual public interest. It's not extinguished, but it's very residual. And the paragraphs after that show why it tips in favour of the individual.
No, the paragraphs after that show why it's residual. I mean, that's the mistake. The paragraphs after that, 134 says, would normally be the case that the balance would tip. In the present case, the residual public interest resulting from the client's problematic actions in his criminal offending has to be seen in the overall context of this highly unusual circumstances of this case. Yes. And then it goes on to spell out what the unusual circumstances are. And it says, well, first sentence of 135 is effectively full public interest would include an assessment of the effect on public confidence in the system of immigration control, and then consider, well, what is the effect on that? Let's say full public interest at that stage at the beginning of 135 is of the grant of leave.
But you don't say the full public interest is limited to public confidence.
No. I'm going to go on. You read the whole sequence of paragraphs. They know full well that they're dealing with public confidence in immigration control, and they're dealing with disincentives to other immigrants. They say that in terms, and you read the whole sequence of paragraphs. They start with the proposition that the public interest may be weakened because the prospects of removal are remote. What is the public interest, given the fact that the public are remote? Let's look at that by 1, considering the impact on public confidence, 2, considering the impact on disincentives, 3, considering, to go on into the end of the Balancing Act, 149.
Well, okay, I don't want to take up too much time on this, but if you look at 138 or 137, they say what you have to balance conventionally is the Article 8 or other convention rights and the extent of the impact on them and how far that impact is proportionate when balanced with the public interest. Then 138, as we've already said, the respondent effectively concedes the prospects of removing the applicant are remote. That's treating the applicant's entrenched position as a fait accompli. Despite the fact that this situation has been generated by the applicant, it would be wrong to ignore the reality of the matter when assessing the proportionality balance.
Yes, and then they go.
Again, that seems to be saying, well, the applicant's created a fait accompli, we have to live with that. That's the starting point for the Article 8 balancing, rather than a factor to be brought into account in the Article 8 balancing.
No, I just don't accept that. They go on then to explain why it is they're dealing with a reduced public interest in the paragraphs that deal with deterrence.
Yes, thank you.
Well,
right.
Bringing back to this concept of he has an ability to change his mind.
Yes.
But he has an entrenched position.
Yes.
I find it an extremely odd concept that you have an entrenched position despite having an ability to change your mind. You've got an ability to change your entrenched position.
Your Lordship is almost inviting me, and I'm going to resist the temptation to start questioning the factual analysis that leads to the conclusion that my client is capable of changing his mind or has come to an entrenched position.
But he's quite capable of changing his entrenched position. I mean, that was the factual finding.
Your Lordship says factual finding. You will look in vain for any passage in which a first-tier tribunal or adjudicator makes that finding, or any passage in which. But I completely accept against myself that the tribunal proceeds on the basis that he has an entrenched position, that he's mentally capable of changing his mind, because that's what they say, and I have to take that as the basis on which their analysis proceeds.
The basic picture seems to be he's in limbo. Being in limbo affects his Article 8 rights.
Yes.
He could get himself out of limbo by changing his mind and then
Yes.
be removed to Belarus. He says, I'm not going to do that. Therefore, the whole onus switches to the Secretary of State to lift me out of limbo by granting me status, which will give me access to various benefits. That seems to be the basic nature of the problem confronting both us and the Secretary of State. And I mean, I do rather question why the appellant is allowed, in effect, to say, well, I've created a fait accompli, and now the onus shifts to the Secretary of State to lift me out of the problematic situation of limbo, which I have created.
The answer is that the tribunal were completely aware that that argument, the argument that your Lordship is just putting, as effectively my argument or my client's argument, would almost always lead to the case being dismissed. The upper tribunal is completely aware of that, but goes on to say, is that actually a realistic way of looking at this case?
What are the features that are so compelling in this case? What do you say those features are that take it out of the ordinary run of these cases, whereas you say they would 99 out of 100 be dismissed?
Well, they are the features that are listed by the...
Are they 44 to 48, that he's got a medical condition partly induced by drug taking and destitute?
Yes,
but those are the conditions that may well apply in every case. Destitution in every case.
Well, if we look at 148, the combination of the remoteness of removal, the fact that taking the applicant out of limbo in 2021 would not materially damage the principle of deterrence inherent in the statutory scheme, and having regard to the overall rationale of paragraph 276 ADE, lead us to conclude that the public interest is reduced to the point of being outweighed.
Right. So it's those features in 148.
And 149.
Well, 149 just describes them as exceptional. It doesn't add any other features.
It deals with deterrence. It deals straightforwardly with deterrence. That the impact of this of granting leave in this extraordinary case would not show a green light. It's the danger, I repeat, of reading these paragraphs in isolation. They know full well that the ordinary case will lead to failure. They ask themselves, well, what actually is the public interest in this case, given the length of the period of limbo and the impact on my client's mental health and so on? And the answer is that there is a strong private life case, and the impact on the public interest would actually, on the facts of this case, not be great.
Just on the facts, he's not in fact destitute, as I understand it, because at paragraph 48 it says he lives in NAS accommodation. He gets the NAS vouchers to enable him to live, which is true for a lot of people who are asylum seekers and so on. If he were in a situation of destitution, he would have a claim based on Article 3. of the Convention and other authorities, which says that that would be unlawful. So the argument seems to be that he's not destitute, but he wants to be in an even better position by being granted status, which will give him access to other benefits and the labour market.
Well, the submission that we've already seen, and the Lordship correctly put to me that paragraph 46 is summarising Mr. Carnick's submissions. That's correct.
I'm sorry, I was focusing on 48, where Mr. Carnick summarises the current position. I mean, it's just to make the observation, your client is not destitute, he doesn't have an Article 3 claim. If he were destitute, he might well do. So we're dealing with someone who's in the situation above destitution, where the state has an obligation to intervene and help, really almost whatever circumstances have led to that. We're dealing with a situation above that, where the particular situation of which your client complains, that he's in limbo, is, to put it no higher, at least partially brought about by his own actions in failing to cooperate with the Secretary of State in relation to effecting a removal to Belarus. So what makes it compelling that even though the state's doing that much for him, he can, by his own non-cooperation, put the state into a situation where it has to provide even more to him?
What makes it compelling is that the picture that he presents is not of someone living stably on NAS support, but someone who has the medical conditions that are described in 44 by Mr. Carnick, in 44 through to 48. The impact of lack of regularisation is worsening that picture. It's not simply a destitution question, it's a stability question. And the result is that there will have been long periods of street homelessness, where presumably will be again in the future if his position isn't regularised. And
if you put it into my Lord's question into Article 8 terms, it is that there is an interference presently with his private life. He's unable to work and unable to develop relationships through work. And by his own actions, he wants to be able to improve. So he has less interference with his private life. And that's
part of the picture, but it's not the sole part of the picture. You're also preventing the negative impact of prospective limbo, of periods of street homelessness in a situation of considerable mental instability, as we see from the medical evidence.
Still in a position of being able to make up his own mind about whether...
As I said, that's the factual basis on which this tribunal proceeded. Yeah. But I do repeat the plea.
I mean, that's a positive obligation, in fact, on the state to provide better facilities by virtue of his own actions.
Well, well, I'm going to go to Abdullah and Hamza in a moment, but none of the cases see as a knockout blow the fact that in each and every case where there's an element of self-inducement, leave must be refused. The domestic cases don't do that, and the Strasbourg cases don't do that. So one's asking, is there a case which the authorities recognise there might be at the margins, which the consequences on the individual's private life do outweigh whatever you can see as the public interest. And that is precisely the analysis that the tribunal carry out.
Yeah, but they carry it out against the background of saying that there's very little private life.
Well, that is unfair, they do say there's very little private life, but they do say
Well, they say at 1, 2, 3 in terms, minimal private life. That's stage 3, fact-specific analysis.
yes, I know that, but that's the danger again of isolating the whole analysis that is inherent in 135 through to 150. Yes, 150 is that no one. I mean, let's just remember what the key to the deterrence argument is. No one looking objectively at the circumstances of whether my client gained from this strategy can possibly think that the life he has actually led is a green light to others. That's the whole basis of their approach to deterrence. Its life has been so terrible in the UK that no one is going to want to replicate it.
Right, but I mean, it seems to me that in your answer you're shifting from the private interest side of the balancing exercise to the public interest side. Because what you've just said is, well, look at how in fact he's been living. No one's going to be encouraged by that, or and there won't be an absence of deterrence. That's to look at the public interest side of it. But if you're looking at the private interest side, there is a factual finding that he's got minimal private life.
Yes, but you can't take that in isolation from, you have a minimal private life described in whatever paragraph it is, I won't go back to it. What's the impact of the state failure to regularise on concerns which fall within the sphere of his private life? The answer is the creation of the lifestyle which he has led up to now. Those are all impacts, the result of the private life, of the interference with private life. Slightly question-begging formulation, but it is the result of that, of the non-regularisation, has been to lead, that my client has led a life which is unenviable in anybody's eyes. So that starts with looking at at whether there's something in the balance on my client's side. The answer is a private life, and the fact that it cannot develop with all the consequences in terms of the life that he's actually led. The tribunal know all this. So if we go, let's do what I meant to start doing quite a long time ago. No, I'm not apologising. No, don't. This is the heart of the case. I mean, the rest of my submissions on authorities and so on we can put to one side, I think, because this is the heart of the case. But if we do take the run of paragraphs together, let's actually do what I keep on promising to do but haven't yet done. You start with 135, which looks at what the nature of the public interest is, in part as a disincentive to coming or remaining here illegally. The stark question in the present case with the principle of deterrence is likely to be damaged by the grant of leave to the appellant. What do they take into account in looking at that? It seems to us that a dispassionate member of the public, considering the applicant's history, would not conclude that the applicant has gained any real benefit from his presence in the United Kingdom over the past 2 decades and more. Now, that's the finding, that is a finding about the circumstances in which my client has lived. He has not forged any family life. On the contrary, his life has been one lived at the outer margins of society. He has been legally unable to work. We accept that he's had periods of street homelessness, become addicted to drugs and alcohol, although one does not, of course, know what kind of life the applicant might have led had he remained in Belarus. A hypothetical member of the British public would likely to say that he conspicuously failed in that aim. So it's not, they're looking both at the impact on my client's individual circumstances and what recognition of those circumstances, the effect of the recognition of those circumstances has on the evaluation of the public interest. They're looking at the two together. They're not looking at them in two separate compartments. And so, my answer to the question, what is the downside of non-regularisation? Well, it's a life lived at the outer margins, legally unable to work, periods of street homelessness, drug addiction and alcohol addiction, and all the medical problems that go earlier. So just dealing with my learned friend's submissions about 136, he says this is looking at the wrong target. It's only looking at public confidence and not at the impact on other people who might be encouraged by my client's example. Well, the short answer is that that's not true about what the paragraph says, let alone what it says in the context of the run of paragraphs. Grant of leave is the last sentence. Grant of leave to the applicant at this point is unlikely to encourage others to follow his example, thereby leading to a general weakening of the immigration system. So,
it says accordingly. Does that follow from what preceded it in paragraph 136?
It follows from the factual description. I mean, that in a way is my point. Read the whole thing together. It starts with an observation about public confidence. I completely accept that. It then describes the factual position in the terms in which I've just read. It then says, accordingly, and the accordingly, being really grammatical about it, relates back to the description of the factual position.
But what's the basis for thinking that those who might be encouraged otherwise to follow his example will know about the incidental details of his life? They'll just see all you have to do is keep your head down, stay under the radar for 20 years, and you'll be rewarded with a regularised
No, I don't accept that. They will see objectively.
How will they see?
Well, read the tribunal decision. It's not magic. This is a case where I accept, the upper tribunal would accept, that in the normal case of keeping your head down, you lose. It's a situation where it's the description of the fact, it's the ability of the upper tribunal to be able to describe his position in the terms in which it does in the middle of 136. That means he's not going to be an example to others because the others would have to know what had led to the grant of leave. You've got to anticipate that the others who are going to be encouraged know what has led to the grant of leave. And the answer is, I mean, if I'm against my own odds, the answer is in the middle of 136. And so, can I just complete this? My learned friend attacks 136 on the basis that it's looking at the wrong cohort, it's only looking at public interest. That's not true on the face of 136 and the accordingly sentence at the end, as I just pointed out. But it's certainly not true if you read 136 together with 148 and 149.
Do you accept that it's the analysis at 136 which feeds into the balancing exercise at 148?
Yes, but 148 tells you how they're reading what's said in 136.
Well, they say in the first sentence it would not materially damage the principle of deterrence, and the reason they come to that conclusion is because of 136.
Yes, put like that, I accept
vital
that.
Consideration in the balancing exercise.
Yes, it won't affect the public interest because there's going to be no one is going to be encouraged to follow his example for the reasons given out in 136. Yes, I mean, yes, you read 136 and 148 together.
Yes, thank you.
I appreciate that at paragraph 130, the upper tribunal refers to section 117B. But whereabouts in the judgment, just if you could remind me, whereabouts do they say that in accordance with section 117B, they attribute little weight to the private life?
They deal with that expressly in 147.
Right. Yes, right.
And so you need, as my learned friend I think accepts, you need to put together the recognition in paragraph 147 of the statutory normative guidance that you give very little weight to the private life, to the observations of Lord Justice Sales, as he then was, in Repire. So the statutory scheme as a whole contains sufficient flexibility to give effect to very compelling circumstances, despite the normative guidance that you gave little weight to private life that has grown up in these circumstances. Maybe worth.
Almost as a matter of logic, if you have minimal private life, which they've found as a fact, and you give little weight to that minimal private life, you almost need no public interest at all before the private interest can outweigh the public interest.
So
in the proportionality balancing exercise, weighing private interest against the public interest, you have here a case of minimal private life, just as a matter of fact, to which, according to section 117B, 4 or 5, you give only minimal weight. If you've taken something close to nil and give it a weighting which gives it almost no weighting, you're almost in a situation where the tribunal would have had to find that there was practically no public interest at all in the counterbalance to be able to outweigh that almost nil weight.
That depends on whether the finding that's recorded, wherever it is.
1, 2, 3.
Yeah, it is 1, 2, 3. It's the start of the stage 3 analysis. Yeah. Finding 1, 2, 3. How does that fit? Can I say it does logically fit into the analysis in 136? The answer is yes. He has a minimal private life in terms of association with others, but the consequence of the restrictions on his private life over the very long period of limbo have been to produce the consequences which are in 136. That's plainly the way in which the tribunal saw it. If they had said, for example, in 1, 2, 3, looked at in terms of associations with others, the private life is minimal. Looked at in terms of the impact of the restrictions, the results are as we find them in 136. We have a perfectly logical tribunal decision, which is the decision they made, and the decision will be that he's lived a ghastly life. This strategy has not worked. And that is a consequence which was within Article 8, with Article 8.
Well, I'd understood you to be submitting, in essence, that there are major interferences with his private life, so that he could not develop a private life. And so that, therefore, the minimal private life is a reflection of the degree of interference there has been with his Article 8 rights.
Yes.
But I have some difficulty about that argument, because there are lots of people who have interferences with their private life, but still go on to actually establish a significant private life. Now, he's been here for 20 years or so, and despite all of that, he only has a minimal private life.
Well,
it doesn't follow from the interference that you cannot develop a private life.
No, but it does follow that in his case, he has ended up in the position that's described in paragraph 136. That is, he is who he is. He is a person who, in fact, has lived through the period of limbo, periods of street homelessness, drug and alcohol addiction, mental instability because of his medical conditions. He is who he is, and the consequences of the failure to regularise have produced the consequence which is within 136. Now, that, in my submission, is if you're looking at it in prior terms, an orthodox analysis. You have an interference with his private life. Does that lead to very compelling circumstances, in the words of the statute? How does it sound in the Article 8 balance? Well, the answer is you look at what the consequences of, or one of the things you can look at, is what the consequences have been on this case. And the fact that someone else will do it differently is neither here nor there. Because you are dealing with the very compelling circumstances of this individual case. I suspect that we're getting to the end of this part of the submission. Let me just check. That's it. I've got a note to deal with the direction on the statutory scheme, which is to be found in 147, but I've made my submissions about that already. Those are my basic submissions on the upper tribunal decision and the answer that I give to my learned friend's attack on the reasoning of the tribunal. There's one other matter, which is that my learned friend alleges a misdirection about the rationale behind 276 ADE 1 Roman 3. The Court of Appeal in this case, in my submission, dealt with that perfectly satisfactorily and correctly at page 112 of the Court of Appeal decision. Sorry, it's paragraph 68 to 70, and I've got it at page 112 of the key documents bundle. We were looking at it yesterday. And if we've got paragraph 68 to 70, paragraph 68 records Mr. Dunlop's submission that there was a mistake by the upper tribunal about the rationale of paragraph 276 ADE, and the very last sentence of 68 says the judges did not say that, and then paragraph 69 says that what they did say in paragraph 142, they set that out. They say that's an accurate summary of the effect of paragraph 276 ADE, and as Ms. Weston pointed out, earlier versions of the rules had set the relevant period at 14 years. Judges also made the point, by reference to the rule, that the immigration rules contemplated that the successful applicant might have spent some time in imprisonment. This again was an accurate summary of the terms of paragraph 276. And the answer to my learned friend's submission of yesterday is in 70, and it's short. In these circumstances, the tribunal was simply saying, as it was entitled to do, and as the Secretary of State accepts, that 20 years residence in the UK was a material factor to be considered.
So when they say refer to the overall rationale, what are they referring to?
Just simply that there's recognising that 20 years is a long time, which...
That's a rationale, is it?
Yes. I wouldn't have used the word rationale, but they're not saying anything more complicated than that.
What, there's a freestanding principle that 20 years is some kind of...
No, it's just long enough to matter.
What, long enough on its own, without...
No, they don't. And as the Court of Appeal have just said in the passage I read, that's not what they say.
Well, where do they recognise that 20 years is irrelevant if you don't satisfy the suitability conditions?
Well, they recognise that it doesn't satisfy the suitability provisions.
Well, what's the relevance of 20 years if you
It's
don't
a long
satisfy...
time. I don't...
So is 15 years a long time?
Yes, and less than 20 years.
Why didn't they just say period of time is a material consideration?
Yeah.
Well,
I mean, doesn't the Court of Appeal itself mischaracterise the upper tribunal's reasoning? I mean, you can see it in the language in paragraph 69, because they quote the tribunal, which says that period of 20 years is an important yardstick. And then in 70, they say, well, they're only saying it's a material factor.
yes, well, that's all they ask.
That seems just different on its face. Important yardstick.
I just don't accept that. It's long enough to count for the rationale of 276 in some circumstances. They know those circumstances don't apply because they say in terms he doesn't satisfy the suitability criteria. But it is a long time, and it's long enough to be recognised in some context. It's a mountain out of a molehill, this point. I mean, as the Court of Appeal say elsewhere, I mean, just in this one paragraph, I mean, it's not central to the reasoning of the upper tribunal.
To my mind, it detracts from concentrating on the family life or the private life that is actually developed. So the period of time may be a function of developing. The longer you have, the more chance you have. Okay. But the essential question is, what is the family life and what is the private life? And so periods of time don't crop up in Strasbourg jurisprudence, I understand. Is that right?
I hesitate to give an ambiguous answer to that. I think some of them do give some weight to periods of time. I mean, my case is a highly unusual case, to repeat the upper tribunal's formulation. Period of time is relevant because of the length of time my client has spent in limbo in the circumstances described by the tribunal in the paragraphs on deterrence that we've been looking at. And if he'd been doing that for a year or 2 years, he wouldn't have taken much notice, I imagine. But you look both at the period of time that has actually been endured as street homelessness and in these circumstances, and you look prospectively at the fact that these conditions will maintain for the rest of his life. I mean,
but why is that linked to 276 ADE? That's what I find difficult. I understand looking at how long he's spent in limbo and what he's done during that time is a relevant feature of the exercise. But what is the relevance of the link to immigration rules, paragraph 276 ADE?
Because it's a long enough period of time to be recognised in other circumstances as finding material consequences. I don't put it any higher than that. That's it.
Well, you don't put it any higher than that, but the tribunal did at paragraph 142. They say it's an important yardstick.
Well, they don't say that any legal consequence follows from satisfying the yardstick because they're very careful to say it doesn't. I'll go back to the tribunal decision.
Sorry, it's paragraph 142.
Yeah, sorry. Just being slow in my own right at the moment. Well, I still don't actually see, I mean, with respect, what is wrong with 141. They say in terms that the leave must be refused by reason of Part 13, correct. Mr. Carnick is still entitled to point to the applicant's 20 years continuous life as representing a material Article 8 private life actor, correct.
Well, is that correct? Is time on its own an Article 8 factor. I thought it was...
Well, it's never going to be on its own.
But private life is different from just time. You can spend 20 years here committing criminal offences and being in prison, and that's going to give you no private life at all.
Of course.
So why is
one thing you
time...
can't say about this tribunal decision is that it wasn't aware. You cannot possibly say that the tribunal wasn't aware that it was dealing with a complicated factual position in which lots of factors are in play, one of which was it's a long time. And I don't, with respect, see the beginnings of an error of law about reminding oneself that 20 years is long enough in other circumstances to have a consequence.
But why, as my lady says, why is time relevant? Time is only relevant because it gives you an opportunity to develop a private life. And if you haven't developed a private life, well, then time is totally and utterly irrelevant, isn't it?
Well, it depends what you mean. It's irrelevant to the network of ties that might constitute the private life. That
might be developed.
Yes. Yes. It is not irrelevant to the personal circumstances that you've endured whilst you are in limbo. Right. It's very relevant to that. If you come along in, say, Abdullah, with a very, very much longer period of limbo than was in fact in play, then the judgments in Abdullah, which one of my few remaining tasks, recognise the answer to the question of whether or not there was an interference which failed to be justified under Article 8 could be different. And so what the tribunal are doing is no more than saying, effectively, I mean, they were very aware of Abdullah, because they would discuss it, and Hamza. Let's pick up Abdullah, pick up Hamza. Are the facts of this case such that, they're very unusual facts, we generate a different answer than those that were given by Mrs. Justice, similar as she then was, or by Stanley Burnt, Lord Justice Stanley Burnton in Abdullah? The answer is yes, they are. No, there's nothing wrong with that. And the fact that on the way they remind themselves that 20 years is quite a long time, see 276 ADE, doesn't falsify that line of logic.
Before we leave that topic, and I'm sorry to take up your time on this, I mean, just in terms of the important yardstick point, I mean, might it not be said that the upper tribunal is, in effect, treating the 20 years as somehow, you know, a especially weighty factor because they're taking the yardstick? And that's why in 143 they're so concerned to look to see whether he has, the appellant has accrued the 20 years or is very close to doing so, because they're treating the 20 years really as some sort of threshold that, if overcome, gives added weight to the time factor.
Well, this is...
Otherwise, why do it?
My respectful submission is that this is rather unattractive over-analysis of this passage. All the tribunal is doing is saying we have a submission from Mr. Carnick that although the suitability criteria are not satisfied, 20 years is a long time, and it's still a long time despite the fact that some of it was sent in prison. Yes, we agree. Does that in any way falsify the approach to deterrence and the approach to the public interest that's been taken in the earlier paragraphs of the same run of paragraphs that we're dealing with? The answer is no. So one has to, I mean, let's take a step back and see the allegations that I have to deal with are the allegations of error of law that Mr. Dunlop makes, in essence. I mean, obviously, this court might find its own errors of law, but on the face of it, those are errors of law that Mr. Dunlop is advancing. They are, first of all, the exclusionary principle derived from the Strasbourg cases. They just don't apply, so that doesn't go anywhere in my submission. I've got just 10 minutes to say about those in a moment. Secondly, the proposition that there's only one answer on these sort of set of facts. That's contrary to the reasoning of the courts, the domestic courts in Abdullah and Hamza, which plainly don't say that. Or somehow or other, the tribunals failed to recognise that he could change his mind. Well, for all the reasons we discussed, that's not realistic either. The whole analysis proceeds on that basis. So where is the error of law? It's not one of the three identified by my learned friend, unless it is in this one about the 20 years yardstick. So can I just deal? I mean, I think I'm at the point where I was supposed to be sitting down according to the timetable. But,
Not quite, I think.
but anyway, can I? I'm the one that said the timetable was too generous, but I was counting, not counting on.
You have until 12:15, Mr. Jones.
Oh, so I've got time anyway. Well, I'm sorry. Yes, I think. Can I just? As I think I've already said, and I hope I can be forgiven this, I don't think many detailed submissions by me on the authorities are now going to really assist. We saw them in some detail yesterday. And my general proposition is that none of them contain a statement of legal principle which falsifies my answers to the three areas of law identified by my learned friend. I just don't. Now, if I can just make that good very shortly. There are case law relating to the Gilberg exclusionary principle. Well, we've seen Gilberg itself. The other cases are Denison, Evers, and Baliktas. I say straight away that neither Denison nor Baliktas are cases which turn on the exclusionary principle. They both state what Gilberg said. And they both conclude it doesn't provide the answer in those two cases. So they're a pretty insubstantial basis for saying there is a general exclusionary principle. Evo is different, as a lady similar put to me yesterday, because there is an issue about misconduct in relation to a threatened future breach of the non-contact order. I've got that the right way around. But it's still pretty limited and doesn't come anywhere near to providing a basis for saying that there is a Strasbourg case in relation to my learned friend's ground one. You can just look at what Denisov says. Denisov is at sorry.
Starts at 9:09.
Thank you. And the Article 8 passage starts at 933, I think. And crucial description of the impact of Gilberg is at 937.
Yes, paragraph 98.
It's 97 and 98. It's both the paragraphs that are under the heading right to respect for reputation. And the principle is stated there as being, important to stress that Article 8 cannot be relied on in order to complain of a loss of reputation, which is a foreseeable consequence of own actions, for example, the commission of a criminal offence. And in Gilberg, the Grand Chamber did not limit this rule to reputational damage and expanded it to a wider principle of any personal, social and psychological economic suffering could be a foreseeable consequence of commission of a criminal offence and could not be relied on. So this point is still located firmly in the consequences of a criminal offence. And at 99 is quite a simple paragraph from my point of view. On the basis of this case law, the court has applied Article 8 to the exercise of professional functions in a number of cases. And that's basically what it's about. It's about employment and right to respect for reputation and professional discipline. So that's all I need for Denisov. I don't think I need to go to either. We discussed that yesterday. Baliktas is at 885. And we want actually at 898, paragraphs 54 and 55. Sorry, 53 and 54, sorry. And I just make the negative point. There is not a hint in 54, or there's not a hint in 54 of an extension beyond the natural subject matter of Gilbert. I mean, that is consequences of criminal offence itself, or similar disciplinary measures that are non-criminal but in an employment context. Certainly not the beginnings of an indication that the principle has any application as such in an immigration or asylum context.
Small point. Would I be right in thinking that this formulation still leaves scope for the application of Article 8 potentially in criminal situations, for instance, if an excessively long sentence were imposed?
Yes. Yes, and I mean, as I say, I mean, in Denison itself and Baliktas, the exclusionary principle was held not to apply at all in Denisov in the context of a criminal offence. But yes. So, I mean, to take your Lordship's example, if a UK criminal court passed an excessively long sentence, it wouldn't be arbitrary, to use the language of the cases. It would be a sentence passed by a court of a domestic court of competent jurisdiction, but Strasbourg could still hold a breach.
Is there an Article 8 case involving sentencing?
There were certainly cases about the schemes. Well, they're probably they're Article 5, actually.
It would be.
I'm not going to answer your Lordship's question because I don't know.
Yeah, but neither do I.
So, yes, the ones I'm thinking of are Article 5. So. And indeed, it might be that you will get the answer to the excessive sentence under Article 5 anyway, but we need to think about that. The other cases, in an immigration context that my learned friend relies on, include Dragan, Ramadan and Shevanova. I hope I can be forgiven for not going to them either. I simply repeat the submission that none of them lay down a general principle which shows that the submissions I've been making today are wrong. They certainly suggest that the fact that the situation is self-induced in some immigration context is going to be highly relevant. I don't dispute that for a moment. But none of them indicate there's only one answer in the way in which my learned friend's second formulation says he must proceed with. Shevanova is a very odd case because there the misconduct consisted of the husband marrying his wife on the basis of what was alleged to be a fraud to obtain a marriage of convenience, despite the fact that the marriage had persisted for a large number of years and had produced a child. And I just draw attention to the fact that there is a dissent on that fundamental reasoning of one of the judges, but it doesn't alter my basic submission. It doesn't take us any further in this analysis. So finally, can I go to two domestic cases, which are Abdullah and Hamza. Abdullah is at page 543. And my learned friend took your Lordship and my Lady to paragraph 22 of the judgment in Lord Justice Stanley Burnton's judgment, page 549, paragraph 22. And you can see, reading it, it's certainly not authority for the proposition that Article 8 is not engaged at all. The position is a result of your own failure to cooperate. And that is even more clearly true of paragraphs 28 and 29 of Lord Justice Beatson's judgment. And your Lordship, I can ask your Lordship to read those two paragraphs and to note that in paragraph 29, Lord Justice Beatson expressly recognises that one of the factors which have been held to affect the period of detention which is lawful is whether the detained person has cooperated with attempts to obtain documentation. So he's saying, look to the case law on lawfulness of a period of detention. One of the factors is whether you cooperated or not cooperated. And he's certainly not saying that the fact that you haven't cooperated in this context must produce a negative answer. It's just not. And without looking up Hamza, we've seen Milady's paragraph 55 paragraph 77. Paragraph 77 is the critical paragraph of page 589, but we've seen it before, cited in RA Iraq. And again, as I respectfully understand it, that's not a statement that you can never get to a situation where...
Sorry, paragraph?
77.
Thank you.
589.
But in any event, it suggests that there is a proportionality exercise to be conducted.
Yes, so if you're looking at my learned friend's three potential grounds, it's certainly proceeding on the I accept, and indeed submit, proceeding on the basis that you're into a proportionality analysis and Article 8 is engaged. And we come back to the question of whether the upper tribunal, as we so actively canvassed this morning, actually erred in considering the particular circumstances of this case came out the other side of the possible analysis.
Do you accept that section 117C applies in this case?
I mean, we've canvassed the argument that it doesn't.
Yes.
But
I wanted to know what the position is.
I am not advancing a submission that we should succeed on the basis that although we would fail if it applied, we succeed because it doesn't apply. I'm not making that submission. We've got to get an answer which is consistent with the statutory scheme. And the fact that this is not at the moment of removal case doesn't, to my mind, remove the need for me to show that the upper tribunal's analysis is coherent and works.
Yes, but the upper tribunal analysed the case on the basis of section 117C, and I just wanted to know whether or not you agreed or disagree that section 117C applies, and if not, why not? I'm sorry for that.
I think the answer is probably no. I mean, this is not a deportation case,
well,
but I don't rely on that.
The argument was whether it concerned deportation.
Yes.
And is there any authority, is there any case law, or is there anything that one can add to it apart from just looking at
Not that I know of.
Okay.
Is it the case, Mr. Drabble, that if leave to remain were granted, then there couldn't be deportation?
Yes. I mean, it couldn't be during the currency of the leave, yes.
So, as I understand it, what's said against you is that it's for that reason that the case concerns deportation.
Yes, but there isn't, I mean, the only relief that's given by the upper tribunal is declaratory and doesn't necessarily envisage the grant of leave.
What does it say about the applicability of section 117C?
But the tribunal, as has just been put to me, the tribunal proceeds on the basis that it does apply.
Yes.
And as I have said, there is an argument it doesn't, but I do not want to advocate an answer which defends the upper tribunal decision on the basis that they mistakenly applied 117 and shouldn't have done so at all. And for that reason, the challenge for their consideration of the consequences of 117 doesn't succeed.
I was asking the question because I wanted to know what the answer was.
Yes, well, I can't produce any more material. If you're asking me whether I know of any actual material that gives an answer, the answer is no. I don't, but that doesn't mean very much.
You're not seeking to persuade us to the contrary? You're not seeking to persuade us to
No, I'm not seeking to persuade you.
Thank you.
My lords and ladies, those are my submissions.
Thank you, Mr. Drabble. We're very grateful. Mr. Dunlop.
Thank you, Madam. Can I begin by responding to a submission my learned friend made about RA? He said the approach in RA will produce lawful answers. That's not correct. It may do, but it may not. And can I take you back to page 740? And this paragraph 71, this paragraph talks about the public interest in a way that suggests that there really is only one facet of the public interest, namely the public interest in removing the individual. And so it suggests that if you can't actually remove the individual, then the public interest becomes extinguished. Now, that is liable to mislead tribunals and courts into focusing on that single aspect of the public interest removing the individual, and to therefore overlook the other important facets or not give them the appropriate weight. The next submission I wanted to respond to were my learned friend's submissions on the facts, and he took you to the submissions of Mr. Carnick appearing as counsel in the upper tribunal. He took you in particular to a submission that you find at paragraph 46, page 253, paragraph 46 of the upper tribunal decision. And he took you to this submission there in that first sentence of Mr. Carnick submitting that those involved in the applicant's care see a pressing need for him to obtain some formal status. And as my Lord Sales put to him, that's just the submission. What's important is the findings. Now, I accepted yesterday that one looks not just at the minimal private life, but also the capacity for improvement. But it's important not to look at what the submissions are on capacity for improvement, but what the findings are. And the findings you can find at paragraphs 144 and 146. As well as a paragraph I took you to, sorry, I think begin with 129, which is page 275. The tribunal do not accept in full the submission or the evidence on which it relies. They say in terms that they're careful not to put undue emphasis on the professional opinion that AM was relying on. They point out the seriousness of his offending, and they say it is plainly unlikely that if he were given leave to remain, he'd become a model member of society. And the furthest they go is they place certain weight on the evidence that shows a capacity for self-improvement. And that finding is picked up again at paragraphs 144 and 146. If I begin with paragraph 144, page 278. If you look at about 3 lines down, the tribunal note that say that there is on the evidence some, albeit modest, reason to think that if given leave, the applicant would begin to turn his life around. And then even that they qualify, because if you go on to page 279, first sentence.
Which paragraph?
Paragraph 146. It's possible that in saying what we have at paragraph 144 above, we may be accused of taking an overly optimistic view of the applicant's capacity for self-improvement. So, in fact, the findings were minimal private life and minimal chance of doing anything better with his life if granted leave to remain. And that's the full factors that he's got on his side of the balance if it's done properly.
And the first sentence of 144 says he's not at present speaking.
Indeed. And I respectfully agree with the points made by my Lord Sales about his present situation. I also agree with my Lord Sales when he put to my learned friend that the obstinacy of the respondent was used as a factor in his favour, and there's frankly no other way of reading paragraph 148 and that first sentence. The remoteness of removal is seen as a factor that weakens the public interest in effective immigration control. And that is to fall into the trap that the unwary may fall into when they look at paragraph 71 of RA, of focusing just on removing the individual. Yes, his obstinacy makes it much less likely we'll remove this individual, but his obstinacy is also a factor that strengthens, if anything, the other facets of the public interest. The importance of not rewarding someone who has been obstinate, the importance of not providing state resources to someone who's only here because of prolonged obstinacy. Just going back a couple of pages to paragraph 136, page 277.
So what paragraph number, sorry?
Paragraph 136.
Thank you.
My lady puts to my learned friend a question about why other foreign national criminals or other illegal migrants wouldn't see this as some sort of reward for his obstinacy. And my learned friend said they'll read the upper tribunal decision and they'll look at paragraph 136 and they'll know what led to a grant of leave. There are many submissions to make in response to that, but I can summarize it. The first point is that is taking the sort of factual precedent approach that my learned friend deprecated. That's not necessarily how an individual would look at this case. They may think, well, I'm not an alcoholic, I'm not a drug addict, I'm not going to go down the path that this man went down. But it's good news that 20 years is now an important yardstick, or it's good news that there is now this one case, first case ever, where someone has succeeded on the basis of limbo, even though it was self-induced. My learned friend also submitted that the failure to regularize has produced the consequences in 136. There is no finding of that, and it puts it far too high. That effectively is to blame the state for the life that AM has led, his addiction to drugs and alcohol, etc. And that'll be a very controversial finding, and it's not one the upper tribunal makes. Finally, on the, well, not quite finally, my Lord Sales puts to my learned friend that the Court of Appeal had, in effect, mischaracterized the decision, downplayed the importance of the phrase important yardstick. And my learned friend's response was effectively to do the same. If yardstick means anything, it means a measure of some significance. You get past that yardstick, that's a point in your favor, as it were, even if it's not determinative. And it simply should not have been a yardstick in an Article 8 case outside the rules. Finally, on this judgment, my learned friend said that the judgment did not require a grant of leave. Well, can I take you to what the tribunal say at the end of their conclusions on ground 1, page 279, paragraph 150. We propose to make a declaration to the effect that continuing to refuse to grant leave would be a disproportionate interference with the applicant's Article 8 rights. Now, of course, the tribunal can't themselves issue a grant of leave, but unless we succeed in the appeal, there's no alternative under this. If we don't grant him leave, we breach his Article 8 rights and query how we're supposed to grant him leave when we don't know his real name. That's a different issue. But it's not right to say this doesn't require a grant of leave. The last point is just for your information. It's not really part of my case, but it's a question my Lord Sales asked. You said that the Gilbert principle leaves scope for the application of Article 8 to criminal convictions, and that's right, and there is in the authorities one example of that, which you can find at page 1027. And it's mentioned in paragraph 69 of the Gilbert judgment, and it's the case of Lasky, Jagged and Brown. And the Strasbourg court found that there was a breach of Article 8 because the convictions, picking up on the top of page 1028, were the result of an unforeseeable application of a provision of the criminal law to consensual sadomasochistic activities between adults.
Sorry, the reference to Lasky is...
It's page 1027.
It's at paragraph 69 of Gilbert.
Yes.
Got it. Thank you very much. Yes.
And I should just check that you received our note, doing our best to answer your questions of yesterday.
We did. Thank you very much. Grateful. Any questions? Thank you very much. Mr. Dunlop, Mr. Drabble, we're very grateful to you and your juniors and to those sitting behind you for the submissions that we've heard and for the written submissions as well. We will take some time to consider our decision. Thank you very much. Court's now adjourned.